British rulers allowed Benami transactions legally. And so that means Benami transactions are happening since then, which will be evident from this fact that Section 82 of Indian Trust Act, kindly see, it specifically allows Benami transactions. Kindly see. Indian Trust Act 1882, Section 82 said where a property is transferred to one person for consideration paid or provided by another person, and it appears that such person did not intend to
I think there is a power issue again because his screen got jammed. Ashish ji, if you are there, can you take over? Ashish ji, are you there?
Yes, I'm here.
Yeah, so if I think the power outage would have, power cut would have happened.
This particular aspect that he's talking about, the Persian background, is best taken by Ashwini ji only.
No problem, sir. Then
Yeah.
we'll just
So
wait.
Since the flow of the slides are in that manner.
Yeah, yes, sir. Yes, sir.
But I can definitely discuss issues with people if they would like to talk on any particular aspects. So if it's not such an issue, maybe we could wait for a minute. In case he is not, then we can try and see if we can talk in general.
Yes, sir. Yes.
On this subject.
I'm rejoining in few minutes. It has come. So same thing because it's happened in the beginning also. There's some power cut. So
no, we have experienced some unruly weather in Delhi.
It's same here in Hyderabad, sir. It's raining very heavily. At least where I am sitting, and frankly, I had to close all the doors to ensure that there is no sound coming out here.
Yeah, we also experienced that in the last half an hour or so. So we had power going away in our locality as well. And I was telling Ashwini ji, I'm not too sure whether I'll be able to join if my Wi-Fi is off. So these are the vagaries of weather that we encounter in the capital city.
Yes. Good. Meanwhile, all others who are there, just couple of things before Ashwini sir joins. Look, from tomorrow, the moment you are clicking on Zoom, you are asked to give your email ID and number. So only thing is, if you can just provide your number also, we can download the list and straight away start giving the CPE hours to such members. So that's why this request. Even still, don't worry. Most of you are given the numbers, and see if a simple name, a couple of names which are coming as D99612 or some like GV sir is there. I know he's a senior person, and D9399 @9F. If such names come, we will not be able to give the CP hours. So that's where we request you, if you can rename yourself, you can just rename yourself with your membership number and name so that it becomes easy. That's all. Yeah, sir has come. Yes, sir. Share screen option is still on for you.
Yes. My apologies. My apologies. Actually, there was power outage because of stormy weather over here. Now I think But today we have the benefit of Tandon ji sir. In between, if I am stuck, you can please take over. Tandon sir.
Yeah, I will intervene.
Okay, okay. Yes. So, so section 94. Now, if you carefully read section 81, 82, and 94, now these sections are saying only one thing. They are saying that in case a person wants to transfer the property to another person, but does not want to transfer the full beneficial rights therein, then the law protects the intention of such person, and the person remains the owner, and only for limited purpose the rights are transferred to the transferee. In another words, a person can do Benami transaction. He can buy the property in the name of somebody else or transfer the property to someone else, but without transferring the beneficial rights therein, full ownership rights therein. So that is how I mean the law, you know, at that time was enacted. Now, if you kindly see section 66 of CPC also gave the similar kind of privilege. Our own Indian Income Tax Act, you kindly see. Now, it also gave this privilege, not 1922 Act. I am talking about 1961 Act, which says that there was an obligation of the person, if he is doing Benami transaction, to disclose the Benami transaction to the jurisdictional commissioner or chief commissioner. That's all. Meaning thereby, Benami transaction could be done. There was permission from the legislature. With the only embargo was that transparency was required to be maintained by way of giving the information to the commissioner or chief commissioner. That's it. So that means the legislature was quite conscious that Benami transaction was probably the customary need at that time, even at British ruler and post-independence, our Indian government also. So that is why they allowed Benami transaction. And if they do not inform to the income tax department, no punishment, no acquisition. Only the rights of the people to recover the property by way of suit, that is a real owner, would have come to an end in case the person failed in giving information to the jurisdictional commissioner or chief commissioner. That's all. So that means there was a whole lot of permission to do Benami transaction. So then you must be thinking, then if the law allowed Benami transaction, then why suddenly we are talking about that it is illegal? When and how the change occurred? For that purpose, I will have to take you to the little historical background. That is in 1969, when for the first time the Taxation Law Amendment Committee gave its first report, gave its assignment to the Law Commission, that there are many reports coming from many parts of the country that Benami transactions are happening in the country, which is creating trouble in the economy. So the Law Commission was 5 years, and in 1974 it came back with its first report, wherein it opined that yes, Benami transactions are happening, and the first reason was not tax evasion, but the first reason was uh, violation of certain civil laws. What laws? Like Urban Land Stealing Act was, you know, brought out on the statute post independence to bring out land reforms, to eradicate feudal system in the society, to make even distribution of land from few landowners to many landless laborers. And many states also adopted Land Reforms Act. There must be some laws in Andhra Pradesh also, Andhra Pradesh Land Reform Act, something like that, because there are many land. For example, Shah Rukh Khan's property was attached under this Maharashtra Land Reform Act because of violation of that only, not that Mannat Banglo. His Alibag property was attached under because of under Benami law, because he had violated certain allegedly violated certain civil laws, land reforms law, by buying the land in the name of the property, by inducting a director who was native of Alibag. So that is how you know, Land Reforms Act were brought out, and certain people were violating those laws. So that was the need, and urgent need was expressed that immediately some law should be brought out. But despite that, categorically funding was given. But despite that, nothing happened till 14 years, when suddenly in 1988, for the first time, uh, this ordinance is brought out in the name of the Benami Transaction Ordinance, Prohibition Ordinance 1988. It is brought out on 19th May 1988, and it receives the assent of the President on 5th May 1988 and becomes the Act. So at that time, it contained only 9 sections. Since the first issue which is arising in our mind is whether this law is going to be retrospective or prospective. Therefore, friends, it is essential to know what kind of law existed at that time, whether the current law can be, dovetailed with the earlier law, or the earlier law has no role to play, only new law will come into force, or the new law will be forced but on earlier transaction also. So this question of retrospectivity, since we have to answer, therefore it is necessary to understand the earlier law also. Now, I will read only few sections from the earlier law. Section 1, subsection 3, which is the commencement section, as you can see, which says the provisions of section 3, 5, and 8 shall come into force at once, and the remaining provisions of this act shall be deemed to have come into force on 19th May 1988. So friends, kindly see, the commencement section is different from income tax commencement section. Every act has got commencement section. Now under Income Tax Act, the commencement section is like absolute terms for all entire act. Like the law says that the whole of the Income Tax Act shall come into force from so and so date. But here it is bifurcated into 2 parts, and this bifurcation is creating the trouble. That 3 sections at once and other sections from 19th May. Now at once means when the act, it was made an act, that is 5th September 1988. And when we talk about remaining sections, it is talking about 19th May 1988. So it is divided into 2 parts. Then section 2A defines Benami transactions. It says Benami transaction means any transaction in which property is transferred to one person for a consideration paid or provided by another person. Now kindly see how short, crisp the definition is. But under prohibitory law, it is not necessary something short or crisp, sweet also, because it becomes sweeping and it tends to cover unintended situations. Like here, the situation of a giving loan by a banker directly to the seller of the property would also be covered because of the literal interpretation like this, which is not the intention. So it shows that definition is incomplete, and it will be also evident from this fact that definition was incomplete when we'll read the present definition, which has got some other tests and provisions attached thereto. Then we had section 3 of old act I am talking about. No person shall enter into Benami transaction. So friends, it is clearly saying that no person shall enter into Benami transaction. That means the law is very clear. No means no. So it is absolutely prohibitory law. So whatever is contained in this law, and it says it to be prohibited, so no person will do it. No scope of reasonable cause was there. That, for example, under income tax law, reasonable cause clause is there, that if some act is done for some reasonable cause, then penalty would not be levied, but otherwise penalty would be levied if reasonable cause not is there. So here no reasonable cause concept is there. No ifs and buts. Straight away it says no person shall enter into Benami transaction. Only 2 exceptions are given in the case of wife or unmarried daughter. Now I don't understand. They left poor husband and daughter also only unmarried, as if she will become married, then she will not be a daughter anymore. And what to talk of son? So only these 2 exceptions. So that means the law was quite wide, quite sweeping, even at that time. And then section 3 says, whoever enters into Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years of fine or with both. So law is defined, commencement is there, and then punishment is also prescribed. Then where did this law go? Actually, here stopped the entire buck. That is in section 5, which says that all the properties held Benami shall be subject to acquisition by such authority in such manner and after following such procedure as may be prescribed. So no such procedure was ever prescribed. No such authorities were ever created. So in other words, no enforcement agencies were created. No appellate agencies were created. No mechanism was created with regard to redressal of the grievances. So it remained like a paper tiger without force, life tiger without life force. So this tiger was put on the outside your doorsteps, And the moment you stepped outside your doors in 2016, life was infused in the tiger in the shape of new Amendment Act, which was notified with effect from 1/11/2016. Now, this new Amendment Act, which is brought out by the present government and introduced by the earlier Finance Minister, Honorable Shri, late Shri Arun Jaitley sir, and uh, the specialty of this law is that it contains 74 sections, whereas this Amendment Act, and whereas the earlier law contains only 9 sections. So ideally, the situation should have been that earlier law should have been repealed and new law should have been brought out, because it is like otherwise inserting large ship into small boat. So this question was also asked from the Honorable Finance Minister that why did not you do like that, removing the earlier law and inserting the new law? So then he said, no, there is a sound reasoning behind it, because we did not want to give immunity to the people who have done Benami transaction in last 28 years. That is 2016 minus 1988. So that is how this legislation has been brought out. That and now, so that is how he gave this reply on the floor of the House, that this law has been brought out in such a fashion that it can cover earlier transaction also. Now, as far as speech given by the Honorable Finance Minister at the floor of the House is clear, that it will be covering earlier transactions also. But that is only one of the parameters to decide the retrospectivity. Let us also see how the law stands, whether the law has been made retrospective or prospective or what. So the way law has been made is that new sections have been incorporated in the earlier sections, and some amendments have been made, and there are certain earlier sections which remain as it is. So infusion is the same fashion, in the same fashion as is done in the income tax law, with the only difference that the commencement section is little different here. So let us read section 1.3, because this section 1.3 remains as it is. There is no change in that. So let us read section 1.3, which is commencement section, which says the provisions of section 3, 5, and 8 shall come into force at once. Now, at once means what? Whether at once would mean now, that is in 2016, 1/11/2016, or at once would mean then, that is when the act was brought out. So the House, I'm sure, will be divided on this. The opinion would be divided. I'm sure about it. But friends, kindly see, this is such a controversial issue that it cannot be analyzed immediately, and the controversy will become more large when we read the remaining half. Now, before I read the remaining half, you must be thinking that what about 358? It remains same or change? I would share with you the information that there is a change in section 3, 5, and 8. Rather, section 8 is totally changed. So now what would be your opinion now? So I know still it will be controversial issue. So let us read the remaining half, because controversial is more large over there. Remaining half reads that, and the remaining provisions of this act shall be deemed to have come into force on 19th May 1988. Quite big googly. Now remaining means what? Remaining means 9 minus these 3 sections, that is 6 sections, or remaining means now it contains say 74 sections, so 74 minus 3 sections. Now remaining means what? I knew that it will be very large controversy, because again, so you know, it is like that is why I salute the people who have drafted this new law, that without doing anything, I would say anything weird, they have achieved I mean something without doing anything weird. And I mean, you cannot even raise fingers, because they have not specifically created the law retrospectively. So now this is giving rise to an absurd situation. So if as seasoned lawyers, we argue before the competent courts like Honorable High Court or Honorable Supreme Court, then the court may say, ki, all right, Mr. Taneja, let us treat section 1.3 OTOs qua new law, because it is giving rise to absurd situations. So OTOs means redundant. So meaning thereby we will not be reading new section this section 1.3 qua new law. Then if it is so, we need to find out whether still there is anything under the new law which would make it still retrospective. So let us try to understand from that angle. So the law has been, as I said, has been drafted in such a fantastic fashion that all possible situations which we can envisage has been already covered in the law. Now, which is evident from this fact itself, that section 2(9), which defines Benami transaction, has been divided into 4 parts: Part A, Part B, Part C, and Part D. Beginning of Part A itself is quite sweeping when it says a transaction or an arrangement. So if somebody would say that, sir, I have not done any transaction, then immediately the reply would come, okay, you may not have done any transaction, but you may have done some arrangement. So a transaction or arrangement, so all right, then don't stop. You can't escape. Read further. So when we read further, it says, where a property is transferred to, comma, or is held by, comma, a person, comma, and the consideration for such property has been provided, comma, or paid by, comma, another person. So kindly see how many commas are there. And there is a magic of comma here only, which I will say that suppose if where a property is transferred to, it is followed by comma. So that means it is a separate compartment. So as we decided a few minutes back that that we will presume that section 1(3) is not here, then the date of transfer should be when the property is transferred to. To apply this law, new law, the date of transfer should be post 1/11/2016. That is whenever the law is applied. Or is held by, okay, then held by, it is separate compartment. So held should be when, of course, if 1(3) is not there, then section 1(3) is not there, then held would be on the date when the action is being taken by the department. So action is being taken when the show cause notice is being issued. So meaning by today. So okay, held now, that means. But held since when? Yes, that is not there. So held since when is not there. Since held since when is not there, so that means when, what would you say? Now somebody would say 1988, and somebody would say even that is not mentioned. So since any time, maybe time immemorial. So the issue is property should be held today. When it is acquired, that is immaterial. That is going to be very, very strong view, which some people will forth, which the enforcement agency will put forth. So held, uh, this word held is creating the entire, magic here, because I will give you one example to clarify my thoughts. Suppose the law is made today that nobody would be holding gun after 1st October 2020, right? And law is made today on 10th June. Now, suppose in December 2020, a person is caught gun in his possession. So whether he can take a pleading, sir, you had made the law in June, effective from October, but I was keeping the gun since 2015. So this law is no more applicable upon me. Can he take this pleading? You would agree with me that no, he cannot, because after all, that was the whole idea, that from this date, nobody will be keeping gun with him. Not that nobody will be buying, nobody will be keeping. So if any person is keeping, he should get rid of. So similarly here also, if the law is made that now nobody, if the property is held by a person and it is Benami, then if it is held, it is Benami. But you may ask that, sir, though example is good, but there is one distinction. And the distinction is that in the gun example, the person had an opportunity of few months, say from June, July, August, September, say 5 months opportunity he had to get rid of gun. But whether any such opportunity was here, so how the example becomes comparable? Then I would say in the answer, yes, opportunity was there. Section 190 of Finance Act 2016 gave this opportunity, that if a person transfers his property to get the benefit and pays taxes thereon, then we will, because in the IDS scheme, pays taxes in the IDS scheme, then we will grant him the opportunity, immunity from the prosecution under Benami law. So this window was there. We did not recognize that window. So that means the person whosoever is holding Benami property can be roped in under this definition. That is one strong view which emerges. So it reads that when a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person. It is similar to what we read earlier. Then thereafter there is one other condition which says and. Now and means other condition is there. We have to make the conjoint reading. Both the conditions have to be simultaneously fulfilled. And what it says, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. So that means this beneficial test should also be applied. If only one condition is fulfilled, it will not be Benami. Both the conditions have to be simultaneously fulfilled. Now, to give you a small example, suppose I call my chauffeur and I tell him, look, Mr. Driver, now this is my car. Now you take it, get it registered in your name, and you have to use it. I have got nothing to do with it. Whether it can be Benami, driver is keeping my car his name now onwards. I had paid for the consideration, but it would not be Benami because second test is not fulfilled. Now, in second scenario, if I say to the driver that, look, you take this car, get it registered in your name, but whenever I need it, you have to bring it. My family needs this, you have to bring it. Anybody on my behalf, I say, you bring it. Whether it can be Benami? Yes, because of fulfillment of this beneficial test, benefit test, second test. So then it can be Benami. Now, part B. Let us read part B also, what it has to say. Part B says, a transaction or arrangement in respect of a property carried out or made in fictitious name. So friends, this is very, very, very dangerous clause, because earlier some people were buying property or getting property in fictitious name, in the name of goddess, deity, in the name of their pets. Now no more. So where from this word fictitious came? Okay, before that, one thing more I want to tell you, that with regard to this retrospectivity, I decided that from earlier date, now the transaction can be covered. Now, what about future date? Suppose I do transaction today. Now, within how many years the action can be taken by the enforcement department, that is Benami Prohibition Unit, to allege that a particular transaction is Benami, a particular property is Benami, whether there is any time limit of few months, few years, 1 year, 2 years, 5 years, 6 years, 10 years, 20 years, or in my lifetime also they can come. Or even after my lifetime, they can catch hold of my children or grandchildren and say, whatever has been left by your father is not a property but a liability. So what is the time limit? So when I talk about time limit, and when I see very complex issues, I really sometimes wonder that what are the logics from where they are creating such kind of provisions, which are very, very peculiar in themselves. So when I analyzed, I traveled back into the history, and while traveling back into the history, I reached back up to 5,500 years when I got hold of a very interesting piece of legislation. Would you believe it is known as Srimad Bhagavad Gita? Yes, by Shri Krishna, same. So about time, what did he say? He said, time is eternal. It has no beginning. It has no end. So they said this, drafting the person who drafted the law, they thought that let us make it as timeless beauty. So why to bind it with time? No beginning, no end. So in past also he can go up to any length. In future also he can go any length. So for time immemorial, both sides. That is how they made an attempt. Anyways, coming back to clause B. So anything in the name of fictitious, not permitted by the government. So what fictitious? First, for the first time, I am seeing having been used in any statutory law. C, a transaction or arrangement in respect of a property where the owner of the property is not aware of or denies knowledge of such ownership. Now, wherever certain people gave any irresponsible answers to the authority, sir, acha, is this property mine? Sorry, I am not aware about. I'm not aware that I'm not owner of this. For example, when such would take place, the ladies of the house would say, I don't know where I am shareholder. I don't know where I am partner. I don't know I am holding this bank account. I don't know I am holding I am holding 2 kg gold. I don't know. So if this kind of is the response, and the response is firm, then clause C hits very badly and makes such kind of properties at Benami. So very, very essential clause to be known now. Clause D says a transaction or arrangement in respect of property where the person providing the consideration is not traceable or is fictitious. So suppose a precious asset is found in possession of a person, and now he would sometime may take quite weird an explanation by saying, sir, asset is mine. I did not buy it. I don't know who paid the consideration. I got the asset. Somebody gave it to me, but I did not pay for it. Now it says that if the person providing the consideration is not traceable or is fictitious, then this such kind of property would be Benami. Now, why this kind of clause has been brought out? There is a sound reasoning behind it. And the reasoning, friends, is that what happens, that such kind of situation which I put before you, they cannot be covered under section 68 or 69. because this person is saying it is not my income, and 68 and 69 is based upon real income theory. So any such undisclosed income cannot be added in his hands. Truly, if we apply section 68 and 69 in its true spirit, so the person used to get escaped. So that is how probably they have said, if you are not clear about the person paying the consideration, we will treat it as Benami. And once you decide who has paid the consideration, then we will see the legal consequences. We may examine the person who has paid the consideration. If he is not able to explain, then we may invoke section 68 or 69 in his hands. So that is how they have tried to cover that if a person is escaping from income tax law, he will be covered under Benami law. So these four clauses put together make a situation like this, that there is no escape from Benami law. Now there are few exceptions. First of all, property held by Karta or member of HUF for his benefit. It's very clear. Second exception is where the property held by a person standing in fiduciary capacity for the benefit of another person and includes trustee, executors, partners, directors or company. Now this is very, very essential clause. Now, one thing I forgot to mention, you must be thinking that what happened to section 81, 82, 94 and section of Indian Trust Act and section 281A of Indian Income Tax Act, which allowed Benami transaction to happen. When 1988 Act of Benami was brought on the statute, all these sections which I mentioned were repealed, meaning thereby way back in 1988, the legislature came out with its simple explanation that endorsement from our side to do Benami transaction is no more into existence. You take care of yourself, put your house in order. In fact, this kind of pronouncement was done in 1988 itself. But surprisingly, section 88 of Indian Trust Act, which provides the fiduciary capacity benefit and privilege and scheme, has not been repealed. So that is of significance. Property is held by the company in the name of the directors, partners, by the firms, etc. A holding company holds shares of wholly owned subsidiary company, also keeps a nominee, then the nominee would have been Benamidar, except but for this clause, he will not be. Then third clause is very important. Friends, actually what happened, since this law has come, it is giving shivering to different kind of people, different kind of shivering to different kind of people, because of giving different kind of tensions. Now, some people are getting the tension because of the reason lest his Benami property is not discovered. Some people, on the other hand, are tense for the reason lest their Benami Rishta, you understand Benami Rishta, I believe, is not discovered. So, some people are in trouble that if Benami Rishta is discovered, Benami property will be discovered. And some people are saying if Benami property is discovered, yeah, they will come to know that this property is owned by who happens to be in some with other relations. So this kind of tensions are probably coming, and when the tensions come in variety, so comes the questions. So one audience asked me that, Mr. Taneja, you said property held in the name of spouse, okay, but who's the spouse? You can laugh. Only one thing is not allowed in my class, and that is being serious, because this is such a tedious subject. Let us make it participative. Let us make it quite lighter, laughter, full of laughter, etc., etc. So I looked back into the law and I said, property held in the name of the spouse, this has been written to make it interesting. In the law, it is written that property held in the name of his or her spouse. So don't be excited. It should be his or her spouse only. Or in the name of any child. Now, another question immediately came as a bombshell that what do you mean by the word child? Anybody, my parents would still call me child. I'm sure Lakshmi Niwazi would introduce Daya Bhai saying that, look, Daya is my child. He is a prolific speaker now. He is leader in the profession. And we are really privileged to have our leaders like Daya ji, Lakshmi Niwazi ji, Pankaj Bhai, and all of you who are really working so hard for the cause of the profession. So any child means child. Now, next clause says property held as joint owner in the name of brother, sister, lineal ascendant or descendant. So friends, what do we mean by the term here, joint owner? Because if you take property in the name of mother, will it be Benami? You may think no, but I am saying yes, it will be Benami unless you become joint owner therein. So if you buy the property in the name of the mother, show yourself as the owner in your balance sheet, etc., you or your client are Benamidar and beneficial owner, etc., etc. I will explain how. So beware of this fact. If you want to buy the property in the name of mother, take the property in the name of mother, forget. Treat it as gift. कुछ भी करना है पूर्ण संपूर्ण भाव से करना है, पूर्ण समर्पण भाव, full devotion. Do something as if you are doing, not just show yourself doing and not doing. So that is why I quite often say that Benami law is important and is close to my heart. Also for the reason that with the help of this law, I am able to understand the law also, not only the law. So with the help of this law, I will understand few fundamentals of the life. So we know how to live life with the help of this law. So brother, sister, father, mother, because linear descendant, and grandchildren, any of them, you have to be joint owner. Otherwise, you buy property in their name, it would be Benami if you are not joint owner. Then power of attorney cases. It gives a saving. But the saving is coupled with two clauses, two conditions. That the power of attorney should be registered and stamp duty should be paid. Yes, you are rightly surprised that these conditions are hardly fulfilled. If these conditions are fulfilled, there would be a pretty good conveyance deed or sale deed itself. But the law is what the law is. So power of attorney cases are prone to invocation by the Benami law. Then I am skipping this fiduciary capacity thing. We can take it up in our complex issues part. What is Benami property? It means any property which is subject matter of Benami transaction and also includes the proceeds from such property. Kindly see, proceeds of property is also covered. So your karma would proceed with you. It is like that. Property, assets of any kind, whether movable or immovable, tangible or intangible, corporeal or incorporeal, and includes any right or interest or legal documents or instruments evidencing title to or interest in the property, and where the property is capable of conversion into some other form than the property in the converted form, and also includes the proceeds from the property. So friends, kindly see how wide and wild the definition is. It includes not only physical conversion, it includes proceeds again. It includes not only monetary conversion, but physical conversion also. Physical conversion means when the raw material becomes finished product, debentures are converted into shares. I'm just giving examples. And jewelry is made out of gold biscuits, etc., etc. So then also property would be covered. Benamidar. How fantastic the definition is. It means a person or a fictitious person, as the case may be, in whose name the Benami property is transferred or held. The fund includes a person who lends his name. Last line, I am very fond of the last line. It says includes a person who lends his name. You know, earlier what used to happen, a person is caught and he would say, sir, this bank account, sir, I do not know anything about this bank account. I just lent my name. I allowed my chairman to use this bank account. He is operating. I don't know anything. Sir, leave me. Now the law says no. You lend the name, that itself is sufficient to put you behind bars. Name lending itself makes you Benamidar. And I will also discuss what is the further treatment which a Benamidar is going to enjoy. The treatment is really fantastic. Beneficial owner. It means a person, whether his identity is known or not, for whose benefit the Benami property is held by a Benamidar. Now again, kindly see. Here it says a fictitious person. Now it says whether his identity is known or not. So I wondered, yeah, how would they catch a person is identity known or not, if person is fictitious? Then again, I got the logic there only in Bhagavad Gita. What did he say? He said, the body is perishable. It takes birth, it comes, it goes. So forget about the body. Look for the soul, find it out, search for it, identify it, catch it, and prosecute it. To be on the lighter side, probably that is the idea, because if identity is not known, what would you do? And similarly here, if the person itself is fictitious, what would you do? The law is fantastic. It has some basic objective which we'll understand very soon. Initiating officer. It means an ACIT or DCIT. Now we understand and we start our association with this law when we talk about ACIT, DCIT, because those brothers and sisters who are into practice of income tax, they would have been at many occasions meeting these officers. So law enforcement work under Benami law has been entrusted upon the shoulders of the income tax department. So law enforcement agency is income tax department. Income tax department has created Benami prohibition unit, which comprises of initiating officer and approving authority, who is boss, that is additional commissioner or joint commissioner, and discharges the function of giving approvals, etc. And then after the enforcement work is done, then matter room, no more remorse remains with CIT appeal or income tax appellate tribunal. No, it comes to adjudicating authority, which is located in Delhi, has member law, member finance, and chairman, and is located at Jeevandeep Building, Connaught Place, New Delhi. And it is the same authority which is discharging the function under PMLA. So for the time being, the work has been assigned to PMLA, adjudicating authority, who is discharging the function under Benami law, and it does hearing as a division bench only, not single member. Under PMLA, it can do single member hearing also. Then appellate tribunal. After the appeals are done by the, after the work is done by the adjudicating authority, then the matter goes to the appellate tribunal. It is the appellate tribunal. It is not the income tax appellate tribunal. It is the appellate tribunal which was constituted under SAFEMA, given the function under PMLA, then FEMA, then NDPS, that is narcotic drugs, then also under Benami law quite recently. It is discharging functions under 7 respective laws. Then administrator, who ultimately confiscates the property. Then brief procedure, how the act is functioning, that is very essential to know. So once the initiating officer gets the information, then it can issue notice under section 24(1) to the Benamidar and beneficial owner, and simultaneously it can also issue provisional attachment order under section 24(3) if he is of the opinion that the property is likely to be alienated, which in 99% of the cases he is of the opinion by rule. So without even applying his mind on this. So during this period, that is what they make this law quite cumbersome and harsh, because here the proceedings begin with the attachment of the property, whereas in income tax law, etc., attachment takes somewhat at the fag end of the proceedings, or even during the lifetime of the assessee, it is not done. So once the notices are issued after his inquiries may be done by the initiating officer under section 19 to 23 of the Act. So once he is clear, he can record reason and issue notice. Once notice is issued, then the proceedings begin as income tax proceedings. But there is a difference in the income tax proceedings and Benami law proceedings, because under income tax proceedings, the burden to prove is based on different concept. Here, the burden of proof is upon the person who is alleging a transaction to be Benami transaction, which has recently been held by Honorable Appellate Tribunal in the case of Pamela Bhardwaj, which was first appeal which was filed by us in the Appellate Tribunal, and wherein Honorable Tribunal has relied upon the judgment of Supreme Court in P. Lilavati and Ammal Mangathai. Ammal Mangathai is a judgment of Andhra Pradesh High Court, which was finally decided by Honorable Supreme Court by Justice M.B. Shah, wherein Honorable Justice has said the burden to prove under Benami law is upon the person who asserts it so. So this judgment has been applied, and then Honorable Tribunal through Justice Manmohan Singh has said that burden to prove under Benami law is upon the initiating officer. It's a beautiful judgment available on the site of the PMLA tribunal. Otherwise, I will send it to Pankaj and Pankaj can in turn distribute. Very good judgment. And then after the 90 days period is over, the initiating officer will decide whether the property is Benami or not. If the property is Benami, if the property is not Benami, he will release. If the property is Benami, he will confirm the attachment order, not confirm, he'll continue the provisional attachment order till the passing of order by the adjudicating authority, and refer the matter within 15 days to the adjudicating authority, and by drawing a statement of case. And then the hearing starts before the adjudicating authority under section 26. It is court-like hearing where the Benamidar, beneficial owner, or any other interested party like tenant, like bona fide purchaser can make their respective claims. And then within 1 year, the adjudicating authority decides whether the property is Benami or not. If it decides it is Benami, it releases the property. If it decides it is Benami, then it confirms the attachment order. Then what happens to the confiscation? Immediately after confirmation, whether confiscation takes place? No. The confiscation takes place after the appeal is decided by the appellate tribunal, and thereafter fresh proceedings are done by the adjudicating authority. So after the adjudicating authority, the matter goes to the appellate tribunal by way of appeal. Appeal is to be filed within 45 days from the receipt of the order from the adjudicating authority. Though the law says within 45 days from the date of the order, but the adjudicating authority gives this privilege by mentioning that it can be filed within 45 days from the receipt of the order. Then, then, sir, few sections, important sections I will be quickly covering up before I take up important issue, and then we can take up question answer session also. Prohibition on retransfer as per section 6.1. So one question arises is whether this law gives benefit of U-turn, whether I can correct the mistake which I have done, whether I can reverse my transaction. Section 6.1 says no. The Benamidar shall not retransfer the Benami property as held by him to the beneficial owner or any other person, and if it is done so, such transaction shall be deemed to be null and void. Then any transaction made after issuance of notice under section 24 shall be ignored, notwithstanding provisions of Transfer of Property Act. So sir, if you have bought any property on which 24(1) was already issued, that kind of property is just a rough piece of paper for you. Those title deeds are nullity because it overrides Transfer of Property Act, and it says no, nothing doing, it will not be of any use. Very, very harsh law. But another question here arises, suppose today I buy property and today there is nothing, no notice has been issued and it is a clean property. But after my buying the property, after a few months or so, if the notice is issued under section 24(1) to the seller from whom I have bought the property, and the IO wants to attach this property, what would happen? Shall I will lose the property or what? Now friends, in this case, there is section 27 which provides protection to the bona fide purchaser. But it is coupled with two conditions, that there should not be any knowledge of the Benami transaction by the purchaser and the adequate consideration should have been paid. Now it is whose burden to prove that these two conditions do not exist? Now again, tribunal came to the rescue in two judgments which we argued, that is Virgo Township and Kavita Infrastructure, available on the site of the tribunal, which again says that the burden is upon the IO. Then friends, next issue when we say compensation on acquisition, confiscation, no compensation will be paid. No claim shall lie against the central government against any vacation or attachment of the property. So even if wrongly attached property later on vacated, no compensation, no claim. Then sir, property to chali gayi. Property, a person is lost. Person has lost the property. Any other consequence? Yes. Then there is prosecution, fine, punishment, etc. So section 53 talks about punishment. Section 53 talks about three things. First, who shall be the guilty of offense of Benami transaction, and under what circumstances and what will be punishment. First of all, who would be guilty of offense of Benami transaction? Where Benami transaction is done in order to defeat the provisions of any law, to avoid payment of statutory dues, or to avoid payment to creditors. First of all, how many laws are there in our country? Uncountable. And it talks about statutory dues, not tax dues only. Statutory dues would include wealth tax, gift tax, income tax, of course, and then octroi, house tax, then stamp duty also. So it could be anything. Then avoid payment to creditors. It will include trade creditors also. So if a person has purchased property in the name of sister or mother, and if the stamp duty payable in the names of females is lesser in the state, then the circumstance will also arise that the purpose of doing the Benami transaction was to save the stamp duty. Then who are the persons who may be held guilty of Benami transactions? Benamidar, beneficial owner, and any other person who abets or induces any person to enter into Benami transaction. Now, because of this third category, I quite often say the time has come when we should align and realign ourselves the way we do profession for our clients, the way we live as citizens of this country, because this time is such that the person who has even advised another person about the Benami transaction, he can also be roped in. Then punishment. So punishment, rigorous imprisonment for 1 year to 7 years and fine up to 25% of market value of property. Market value of property when the transaction was done. So now friends, kindly see. Now situation is very strange. Now this punishment is for whom? It is not only for category 1 and 2. For category 3 also, that is person who abets or induces, the punishment is same. So a person who has advised, he is also liable for imprisonment and fine up to 25% of market value. So very harsh law, sir. Then on wrong information also, there is a fine of 10%, etc. I am skipping these sections and let us come to the interplay. interplay we will take up tomorrow also under PMLA law. I am now skipping some of the lesser relevant sections here today. Yes. So I will take up only one very important issue. How is the interplay going to arise between income tax law and Benami law? Though I would say interplay is there with every other law. With regard to money laundering law, we will take it up tomorrow, how it has got interplay with Black Money Act and Anti-Money Laundering law. But for income tax law, I will take it up today itself. Now, this law has got two sections, section 60 and 67. Section 60 says that this law is in addition to any other law, not in derogation of. Section 67 says that in case there is any inconsistency in the provision of this law or any other law, then the provisions of this law will have overriding or supersession effect, overriding effect. So if violation has taken place under income tax law and Benami also under same transaction, then the effect will be cumulative. The punishment may be there also, here also. But it is not in every case the situation is going to be cumulative. Under certain situations, it can be mutually exclusive also. That is, action under one law may mutually exclude the action under other law. Now, I will try to explain this with the help of few small two examples. Then we can of course take up question answers. Now, a person made surrender during the course of search, say of rupees 25 crores. Now the breakup included of the surrendered amount 10 crore rupees having been received as share capital from 1B Limited into his company R Limited. His name is Mr. R, and R is director and shareholder of R Limited, along with his family. So he pays taxes thereon. Later on, he thinks that matter is over until he receives a notice from the income tax department, Benami Prohibition Unit this time, wherein he is called for a statement by the IO, that is Benami Prohibition Unit officer, enforcement officer. And he starts recording his statement. Yes, Mr. R, you have made surrender rupees 10 crore. He says, raising his collars up. Yes, sir, I have paid tax also thereon. All right. So you received check from B Limited. He says, yes. So that means before receiving the check, you may have paid cash because you are saying it is bogus. So answer, now sudden silence is there, but silence will not convert it into no. So that means you paid cash to B Limited, and B Limited in turn gave check to R Limited. R Limited in turn gave share certificates to B Limited, and B Limited is holding those share certificates. That means B Limited is holding those share certificates in Benami name. You are the real beneficial owner of those share certificates. Now, friends, now can there be any debate on this? Now, IO makes attachment of these share certificates, make also attachment of rupees 10 crores lying into the bank account of B Limited, or makes attachment of the property which B Limited has purchased from these rupees 10 crores. Now, where is the scope of debate? Now, since the facts have been admitted by Mr. B Limited, by Mr. R himself, so how would he say that the share certificates B Limited is holding is not in Benami name? Though there is another view which says that the share certificate is not an asset itself. The assets are artificial. So since assets themselves are artificial, Benami law will not come into picture. But sir, there is a ticklish situation, and situation is really, believe me, very, very ticklish. So the only debate could be that the asset could be at the best these shares, not that 10 crore rupees or the shares attached. So, welcome to the world of Benami law. So he makes payment of under section 68 of bogus share capital, then his shares are also attached, then he will be paying fine, etc. also thereon, and prosecution, punishment, etc. extra. Then I will share one more example with the help of which you will understand what I am trying to say. Then we can take up the question answer session thereafter. One gentleman sold a big chunk of land, say 100 acres, and to get agricultural land, and to get the benefit of deduction under section 54B, he purchased another land and claimed deduction under section 54B. During the course of assessment proceedings, the assessing officer gave a show cause notice under section 143, read with section 142, giving show cause that the gentleman is not eligible for deduction under section 54B because he has purchased the land in the name of his daughter-in-law and not in his own name. Now the reply was given by the accountant of the gentleman, who was very bright chap. He said, "Sir, my boss is the real owner, and he is the de facto owner. He has purchased land in the name of daughter-in-law because of social exigencies. But kindly see, he is exercising the full dominion and control of the land. He is depositing the entire income arising from the agriculture operation into his account. So he is the real owner." So for a change, the assessing officer allows the deduction under section 54B, taking the benefit of judgment of Honorable Rajasthan High Court. But the peace does not prevail for longer time when three notices come from the Benami Prohibition Unit. One in the name of daughter-in-law, alleging herself to be the Benamidar, to the boss, the gentleman, alleging himself to the beneficial owner, proud beneficial owner, and third notice to the bright accountant, because he was again and again saying, on my advice, they have done it so. And the land was thereby attached. So welcome to the world of Benami law. That is why I say that we may not be doing practice of this law, but basic awareness is required so that we can give holistic legal protection to our clients. So friends, there are many more such examples which I can share, I would share maybe tomorrow. And but today I think we have devoted sufficient time, and let us save time, some time for the question answer session also. And during that scenario, we can take up the remaining issues if there are any. So with this, I think we can bring the rest to the deliberations as of now. And I am doing stop share, and then we can take up the question answers also. If there are any issues,
Yeah.
I'll be most pleased to give.
Yeah, thank you very much, sir. Ashish, you would like to add anything from his point?
Yes, Ashish ji. Whatever things before we take up the question answer, if any special point you would like to add, or you would cover up during question answer, as you may please.
Yeah, I would definitely would want to say some things, but the forum is at large, and I think I should not impinge on the space and time that is for the people who have a lot of questions in their mind, particularly after this enlightening session of Ashwini ji. So we would rather interact and give them the response than a one-way communication.
Yes, sir.
Friends, I think the questions, you can just put it in the question answers. We are also having the similar problem, Ashwini ji, here, because today in fact, I got almost about 13 to 14 messages continuously saying there's a power cut, we are unable to have what to do and all. I said, don't worry, I'm recording the entire session. This recording would be shared. But there's a massive rainfall here, and that's the reason why we have this low attendance. I think quickly I'll go to the question side. Ashwin sir, I will read the question slowly, though you can see the question. I will read it out louder so that this is.
Before that, sir, let's do one thing. Before that, whatever questions you have, recording will be posted by the Pankaj ji, and tomorrow you hear this recording, and tomorrow we will take up the remaining questions. You can shoot the questions in advance, or you can shoot it tomorrow also. Yes, Pankaj ji, please go ahead.
Right, sir, but the recording may not come straight away tomorrow because the size is very high. It takes some time because I have to give it to the person to edit it, and then they will be putting it. Recording will.
Sir, it is half an hour's job. I do recording every time.
Yeah, ठीक है, मैं आपसे सुन के कर लूँगा, कोई problem. I'll just go to the first question. Sir, question is from Anand Sharma ji. Does property located outside India comes under the purview of Benami Act? And if the answer is no, how does this get covered?
Anand bhai, very good question you have asked. And this question was asked directly from the finance minister also. It was put to Honorable Finance Minister, and he wittingly replied. He said, he did not say does not reply. He said, for properties located outside India, we have brought out Black Money Act, and already PMLA law exists. So very wittingly answer was given, and I will explain what he meant actually. In fact, the territorial jurisdiction of the India under Benami law extends to under India only. It does not extend to countries outside India. Whereas under Black Money Act and under PMLA, it extends to outside India. We have territorial arrangements. We have mutual agreements with them. For example, properties located outside India, if they are derived from proceeds of crime, which we will discuss in detail tomorrow, those can be attached by the Indian government also with the help of administration outside located. As far as Benami properties located outside India, no, nothing doing. But there could be a situation where international transactions are done in such a fashion that the transaction is international, but the property is located in India. For example, I will give you two examples, one of NRI and other of international share structuring. Now, one gentleman who is based outside India, non-resident Indian, he wanted to buy land in India. So since NRIs in that state, it is a case of Gujarat, were not eligible to buy land. So what he does, agricultural land particularly. So he took help of his friend and he sent his money to his friend and asked him to buy the land in his name. His friend bought the property, that is land, agricultural land, in his name and was keeping it. One day when search took place, during the course of search, the questions were put to that Indian friend that, look, there is some exchange of own money as has been alleged by the builder from whom you have purchased the land. Now, to save his skin, he simply said, sir, I do not know, I have no idea. This land I have purchased on behalf of my non-resident friend. I am just holding it for him. I have got nothing to do. So whatever would have been done under income tax law or not, but BPU comes into action, attaches this land as Benami property, treats Indian friend as Benamidar, and that for non-resident friend as beneficial owner, and prosecution will start of both. His Indian friend can be started at any time, and foreign friend, whenever he will step into India, his prosecution can also start. So welcome to the world of Benami law. Another example which I wanted to give was, suppose there is one US company which wants to invest into the shareholding of Indian company, but does not invest directly, comes through Mauritius route and creates a Mauritian entry, and Mauritian company in turn creates Indian entity and makes investment in shares in Indian company. So shares are held in India, right? Indian company shares. Now, in one case, what happened? The income tax department invoked GAR, G-A-A-R, General Entity Avoidance Rule, or Principal Purpose Test, and denied the benefit of Indo-Mauritius Treaty by saying that the real beneficiary is not Mauritian entity, but US entity. So now this matter can escalate under Benami law also. Indian asset, shares held in India can be treated as Benami asset, US company as beneficial owner, and Mauritian entity as Benamidar. So that is how international transactions can be covered. Yes, sir. Now you can take up the next question.
Yeah. So the next question is that during the demonetization, thousands of crores were deposited in Jan Dhan accounts without the knowledge of account holders. Does this come under the purview of Benami law? And if yes, once the money was confiscated after due procedure was followed, under whose coffers does the money go and how it is to be used? Is there any procedure?
Now, in fact, Deepak Ladda ji शायद
Deepak, I'll just Deepak का mute कर दे रहा हूँ. ठीक है sir.
So in fact, this Benami law provisions with regard to movable assets are strangely drafted. Now, with regard to immobile property, you can immediately point out that the property is name registered in the name of X, whereas the real owner is Y, etc., etc. But in the case of movable assets, since assets cannot be registered, we have to gather it from various other parameters. Now, for example, here, if a gentleman is holding the cash in the bank account, and if he says, ki, sir, it is not my property, I am holding it for someone else. So, I mean, if the test which have been provided under the definition of Benami law can be fulfilled and the property can be treated as Benami, unless he says something else. So unless the reasons are something more, that for example, he is holding it as advance, he is holding it as custodian, or some other arrangement is made, etc., etc. But otherwise, if he is holding it as owner, which without disclosing it, and whereas the real owner is someone else, so what else is Benami property? This is Benami property. And if the account itself he says, no, no, sir, this is not my account, it is just in my name, but it is otherwise the owner of this account is someone else. I mean, it will straight away be Benami. It's a very difficult situation for people who have done the reckless things, the careless things. Yes, sir.
Thank you, sir.
Yeah.
So I'm just
now, with regard to confiscation, The confiscation will take place only after the appeal is done by the appellate tribunal. The confiscation procedure is unlike the procedure prescribed under PMLA. Here, the confiscation will take place only after the appellate tribunal, and no such and the proceeding will begin with the proceeding will be done by the adjudicating authority afresh, and only then confiscation order will be given. Not like ED is doing confiscation, etc., or taking possession, etc. Yes, sir.
Yes. So I'm going to the next question, sir. Whether the property is declared under VDA scheme 98, which provided exemption from allied laws applicability, did they also cover the Benami laws?
No, sir. I think unless the law is specifically mentioned, the immunity is given under that very law only. And I don't remember whether any Benami law word was used therein. If it was used only, then immunity will be given. I will have to check, but to the best of my memory, no such immunity under Benami law. Yes, sir.
So
Next,
I'm
sir.
just going to the next question. Is the residential status of individual important at the time of Benami's transaction or at the time of proceeding or both?
So residential status has no meaning. Situs of the asset has meaning. Where the asset is located is important. It could be resident, it could be non-resident. Assets should be located in India. Yes, sir.
Sir, I could just figure out one question in the chat box also. Is Benami law, does Benami law overrides other laws?
Yes, sir. Look, now there has become a fashion. Now the fashion is like that. Every law states, every law says, probably this question has been asked by Hari Prasad ji. Sir, in fact, this has become a fashion that every law has this clause that this law overrides the other laws. So how the things will happen when every other law will look at other law? For example, there is a fight between the insolvency bankruptcy code and PMLA. So similarly, there will be fight between Benami law and IBC also. So the way I have understood is that as far as any specific provisions are covered in a particular law, so then a specific provision will override any general provision in the any other law. So that is how probably case to case basis only we will have to decide how the overriding effect will be dovetailed.
Yeah.
Yes, sir. There are two more questions. One
Yeah,
from Vishnu.
couple of just thing I'll take up from here. Like what will happen if
just 1 second. Tandon sir, wherever you want to add anything, you can please pitch in, or any question if you would like to take up.
Sure, I'll do that.
Yeah.
Ji, sir.
Sir, I'm just taking one question. What will happen if a person is acquitted by the special court in trial, but by that time the property is already confiscated? It is from Prachi Sharma.
Prachi ji, I think you are mixing up PMLA provisions here. Here the special court has no role. The confiscation will be done by the adjudicating authority only. So confiscation, conviction, that we will discuss tomorrow when we'll discuss about anti-money laundering law. So there you can please ask the question again.
Yeah.
Ji.
Similarly, I think Bhaskar Baira wanted to check if power of attorney transactions are not discussed. We are going to discuss it later on, or
No, I had discussed power attorney transaction. I have said the exception has been given for power attorney transaction, but there are two exceptions to it. There are two mandatory conditions for this. Condition number 1 is that the power attorney should be registered. And the condition number 2 is that the stamp duty should be paid on such transaction. So if these two conditions are fulfilled, only then there is a saving for power attorney transaction. Otherwise, they may also be treated as Benami. Yes, sir.
I'll take the question of Vishnu Mettu, sir. An NRI living in USA transferred money to his mother in India to purchase a property in her name. Later on, the mother has gifted this property to his daughter without the consent of her son. Is this covered under Benami law? And can the son claim the ownership of property?
The moment son claims the ownership of property, it will be Benami. If son does not claim the ownership of property, it is not Benami. I would explain this thing in such manner that whatever you do it from heart. You should not be only seen it doing it. You should be actually doing it. When you give property, cash to your mother, okay, you buy property. It is mother's property. It is her will, whatever she wants to do. And if you still wants to claim the ownership, that means mother was keeping it as Benami and you were beneficial owner. Then it will become Benami, not otherwise.
I
Yes,
think
sir.
when Lakshmikant Rathi has put it in chats. I request all of you not to put the questions in chat because I'll have to keep on moving here or there. So put the questions in question answers only, please, so that we get the benefit of Ashwini sir's present here. Okay, don't put it in charts, please. But still, I read out this Lakshmikant Rathi's question. See, if the property is registered in the name of Mr. X and he is not treated as Benamidar in the show cause notice, but treated as beneficiary, whether the Benami law applies here.
No, I think there is a serious lapse on the part of the Benami law department because the person who in whose name property is registered, he has to be treated as Benamidar only. He cannot be beneficial owner. And if he himself is a beneficial owner, Benami law does not apply. But one thing I would like to say you, sir, that you must have heard that story that there used to be a monster. You kill that monster and his blood drops fall on the ground. Other monster, takes birth. So under Benami law, once you kill it on legal grounds, it can take birth again. So it has happened in many cases that it takes birth again. I mean, the moment it is finished on legal grounds, fresh notices are issued. So there is no need to be, getting excited too much. Even if this notice is quashed, another notice will be issued. If it is Benami, I mean, the chances are it will be ultimately covered by the income tax department. The system has changed. New era has begun. Now the justice will be real. Yes, sir.
या देवी का कोई पुनर्जन्म होगा तभी ये कुछ बंद होगा. Sir,
Or we align ourselves, realign ourselves.
Yes, sir. Sir, just one more question. What are the steps government is taking to identify Benami transaction? It's from Runalini.
Mrinali, government has done a little bit on which many people are playing now. They have, created a small toy and people are getting attracted to it. By the law has been drafted in such a fashion that the IO is getting information on pull mode and push mode both. Pull mode means he is empowered to seek information from anyone, any state government officer, central government officer. Push mode means the law has been created in such a fashion that in case any person comes to the knowledge of Benami transaction, any person means any officer, then he is duty bound to report it to the jurisdictional initiating officer within 60 days. Judicial initiating officer means of the Benami prohibition unit of that city or state. Then, even if as if it was not enough, then they have brought out with the scheme of who will become millionaire and billionaire. They have brought out this reward scheme that whosoever reporting Benami transaction will get a reward. So Benami law officers are flooded with the information about Benami transactions, particularly during the course of search, surveys, then money laundering, ED department actions. Information is served on the platter. Sir, yeah, this asset. No, sir, this asset I have got nothing to do. So this is of his. So why it is registered in your name? Or if this is not your assets, then why the papers are lying in your house, etc., etc. So that is how things are happening. Yes, sir. Next question, please.
Yes, next question is from Mr. Vijay. Do nominee will also be subject to Benami proceedings if bank account and the shares are held in demat, which is attached under Benami law?
Sir, कुछ चीजों का ना, there are certain things in life which may not be themselves sufficient enough, but can become a very good trigger point. So नॉमिनी होना एक अच्छा ट्रिगर पॉइंट तो हो सकता है. और वो कैसे हो सकता है कि नॉमिनी है तो भाई क्यों है, फिर अब इससे इंक्वायरी शुरू होगी तो भाई पैसा कहां से आया था, नॉमिनी से कोई लिंक है उसका, इसका बेनिफिशियल यूज किसके पास है, इसकी टाइटल डीड्स किसके पास हैं. So mere becoming nominee may not be enough, but if the whole circumstances are taken and it fits into that story, so it will nail the coffin ultimately. Yes, sir.
The exception is of fiduciary relationship.
Yes. Tandon sir will explain it very well. Yes, sir.
So in case the nominee, if he is acting in a fiduciary capacity, in that situation, that exception would be invoked and they can escape it. Yes. Other than that, it will be a
very right.
Yeah, Ashwin sir, can we take the questions because questions are keeping on coming? You want
yes,
to stop it, but yeah.
No,
next question is again from.
I have no problem.
Thank you, sir. You are great. Property received under will. What is the status? If it happens to be gift, will the answer is different?
To my mind, there is no problem. देखिए, look, I will explain with the help of one fundamental principle you keep in mind. Whatever you are saying, if that is a reality, no problem. Whatever you're saying, reality is something else, there is a problem. So long as there is no duality, no problem. Meaning thereby, if the gift is gift and the will is will, no problem. If there is something behind it, there may be a problem. If the gift is something like that Mr. A is gifting the property to Mr. B, but the real intention is not to transfer the property, but to transfer the income only. But Mr. A wants to remain the owner, or the transfer is to hide the property from someone. Mr. A enjoys the beneficial ownership, but B is only a namesake donee. So then there is a problem. If the gift is real gift, no problem.
So as Ashwini ji earlier said, that the body and the soul has got to be of the same person.
Yes.
Yes. Perfect. Sir, the question from Lakshmikant Rati again, whether the property which is not transferred before 1/11/2016 but held after 1/11/2016, whether the Benami law still applies to the property in subject, it's held.
Sir, that is what the problem is. On the date when notice is issued, if the property is still held as Benami, there is a problem. There seems to be a problem. Though this issue, sorry, I forgot to mention these things to the viewers. Now, there are three kinds of judgments which are available in the country. One from Chhattisgarh High Court, which says it is retrospective. Two from one from Calcutta High Court, another from Rajasthan High Court, which says not retrospective. The matter is pending before Honorable Supreme Court, so let Supreme Court decide it. And but this word held is creating trouble as of now. Yes, sir.
Yes. Sir, what I think the questions are no longer there, sir. But again, I think Dhanivas Sharma also came, and I think he is also there. Yeah, I think thereby, I think again suddenly some Pradeep Narayana has put a question. Pradeep Narayana says now suddenly the questions start coming, sir. Pradeep Narayan is asking, is there is a time limit for operation for this law? Or the Gita ka updesh aa gaya.
Sir, dekho, as I said earlier, time immemorial. Neither there is a boundary for the past nor for the future. So just keep thinking, this is a fantastic piece of legislation we have made. Then Pramod ji again asking, sir, till now, how many Benami cases have been initiated? Yes, there are cases. And the cases ultimately reach to the adjudicating authority here in Delhi only. So it's not a matter of number of cases. The matter is of intensity. If you kindly see, now there are pretty good cases which are troubling people. The consequences are very harsh. So, I mean, just saving from the tax and then getting deep into the well of Benami, no prudence lies in that. Ji, sir.
Right. Sir, last question, Hari Prasad ji. How after the death of the main SSC, recipients are answerable without their knowledge about movable property?
If they have no knowledge, department will have to bring the knowledge and will have to prove that this is Benami. If department cannot prove Benami, it is not Benami. If department can prove Benami and the recipient is not able to rebut it, it will be Benami. He may not be liable for prosecution, but property will be taken away by the government.
Yeah, as long as they don't stake a claim to the property, they don't invite any consequences.
Thereby, see, I'll just, before I ask Thereby to speak, I'd like to tell everyone, kindly put the questions. Don't worry. I am on the mic because I have to do some more process here. So let questions keep coming. I'll copy it up, and tomorrow, Ashwin sir and we'll be continuing. Hopefully, we'll be with a good weather tomorrow, and we'll have more time to answer the questions and all. But thereby, you can just give there.
One of the favorite quotations of Ashwini ji is that, the law has got to be seen in light of the mausam. Mausam kaisa hai?
और मौसम जब आशिकाना, अश्विनी जी बात कर रहे हैं तो मौसम तो आशिकाना ही रहेगा सर, बारिश उनके वजह से हो रही है.
अच्छा देखो, मैं दया भाई ले उससे पहले मैं एक चीज लास्ट में कहना चाहता हूँ, उसमें शायद आपके बहुत सारे आंसर्स मिल जाएंगे. What we are getting a message now from the government through this law is, if we read it harmoniously, is that whatever we are doing, whatever we are thinking from inside, we should look to be thinking from outside. Whatever we are from inside, we should look to be outside from that. Whatever is mine, I should think to be mine only. And I should tell others also to be mine that only. Which is not mine. Neither I should think it to be mine, not I should tell anybody else to be mine. So get rid of Benami law, Benami life, and live real life. Thank you very much. जी दया भाई.
There, bhai.
सर जो पंकज भाई बोले, जस्ट टू कंटिन्यू, यही आशिकी के अंदर भी गाड़ी में आके बैठ के आपका सेशन सुन रहा हूँ सर मैं. That's the only thing I can tell you is amazing. It is always interesting to listen to you. And undoubtedly, tomorrow's session is going to be something very important, I think, Ashwini ji. Now, Deepak also is showing that he is also in car now. So life has become, a mobile all throughout. And Nami or Benami, abhi to everything is going all together. But the fact which goes, Pankaj bhai, tomorrow's session, which is on PMLA, prevention of money laundering, please understand one point which is applicable for all our viewers. Is the first act which triggers anything is basically the anti-money laundering. When the money laundering actually starts happening at the national and international level, what happens is it creates the Benami properties. Am I right, Ashwini ji?
Yes, sir. Yes, sir.
So primarily, when you look at money laundering happening, this money comes back in some other form, and primarily it goes and reaches out in form, and the output, is it breaking, Pankaj bhai?
Yeah, आपका
Because I'm
थोड़ा voice
using
break हो रहा है.
mobile data.
Yeah, in fact, what had happened was one Rajendra Pagdi ji had started asking the question when Ashwini sir ka power outage ho gaya tha, and for a long time we wanted him to, he stayed back, but somehow, so I will just give him a privilege to talk because
Yes,
he
yes,
has
please,
the
please,
question.
please.
So I think,
Please go ahead.
please, sir, Rajendra, you can talk, sir. Rajendra ji, you are available?
Yeah, I'm available. Can you hear me?
Yeah, we
Yes,
can, sir.
Rajendra ji,
Please.
please
No,
go ahead.
I think my question when I started was quite premature in the sense that that was concerning PMLA. So I've just posted a question on this chat box that where can I send the question for tomorrow's webinar on money laundering. I had raised that question on 4th March when Mr. Ashwini ji was in Hyderabad. It was very interesting, but one thing I want on a lighter note, as he's continues to remind us that this has to be a dry topic and it has to be very light. That day in the hall, that air conditioned hall, the hall was packed and very senior members were there, and 3 rows behind me were 2 gentlemen who were coughing seriously, and I was scared because by that time Wuhan was almost all over the world in the news. That is on the lighter side. On the serious side, I wanted to raise the question in the seminar on 4th March also. See, I wanted to bring to your kind attention the, 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 the experts on the webinar today. These real estate transactions that are happening, the real estate transaction that is still happening in the country are loaded with 2 components. One is the market value as fixed by the state government, and another is the real value. The registration value and the real value are 2 different values. So thereby there is a huge cash is generated. One of the great disadvantages of the country is this buyer does not want to part with the registration charges of 6% or 10% depending on where you are getting it registered. And the second part is the 20% long-term capital gains which the seller doesn't want to pay. Now, in the given circumstances, whereas the law is there very much in place, but the reality on the ground is that the transactions are continuing to happen. The SSCs and our clients are facing this problem on a daily basis whenever they are selling precious property all over the country, particularly agricultural land in the vicinity of major metros, which the prices, what has happened to the country, in the country. Thereby, of course, we have deprived the poor people of reasonable housing today because of huge amounts of foreign capital coming in and funding real estate. That apart, what is the solution for these things? So if I'm selling a property of 1 lakh rupees, I'm getting something like 25,000 rupees by check and another 75,000 by any other means. So there is a amount of quantum of cash that is generated. I don't know if it is right to bring up this thing on the webinar, but that is a fact of life. Maybe you
So
can.
Sir, if you don't wear a legal mask, you risk infection.
Yeah.
Ashish ji has answered it fine, I think. Yes.
But I'm looking for a solution.
You will always be vulnerable.
I agree. What's the solution? Don't do the transaction.
Stay away from such transactions.
Absolutely, I agree. So
Yes.
We cannot twist the economy like this, because in this manner our entire economy has been broken into pieces because of this parallel economy only. So that is why, I mean, we will have to do certain things which ultimately keeps us away and makes us a robust economy. And the only thing which is coming in our way, the major thing is this, that we have broken pieces of streams. So I think something would have to be done by the government, and that is why they are taking these steps. And we'll have to cooperate the government in this regard. We cannot, as a professional, we cannot come as a stumbling block, because our profession has passed through tough times in the past few years, and I think we'll have to stand up to the current need of the economy and the country. That is what I would say at this forum and at anywhere. I mean, this is actually our genuine need.
Yeah.
And as far as your second question is concerned, where should I ask the question, sir? I have given my email ID, ashwini@texindia.net, where all the participants can please raise the questions. You can CC it to ashish@texindia.net. Also, my esteemed colleague is there with me. I will give his email ID also, ashish@texindia.net. So he can give anywhere, and we will try to answer them by today. During these 4 days, anytime, whenever we get chance. During these 4 days, whatever questions you have, keep on raising those questions, and we'll try to keep on answering to the best of our knowledge. In this process, we will also learn something, some new queries will come up, and we will deliberate on it. So only request I will make is that please maintain the grace of the forum, raise those questions which should be asked on this forum. I mean, that is what I will make, but we will try to answer all such questions which can be answered.
Yes. Sorry, Ashwin bhai, I took the time only up to 7:30 aapka, or I just extended it, and before I'll say sorry for the next 4 days also abhi, क्योंकि मुझे मालूम है कि ये जाने वाला है आगे. And Ashish ji, thank you very much. You are there. Or definitely we would also invite you to come and speak. And sir, आपका जो physical presence की बात है, I think now again the demand will start. I pray that this government lifts the restrictions soon, so that we can again see you personally. But at the same time, I'd just like to stop because we have time till 8 o'clock. And first, I will thank both Ashish ji and you, sir, for sparing time. And I request our Secretary Deepak Ladda to propose a formal vote of thanks to all the people who are there with us today. And it's still raining badly in Hyderabad, sir. I don't know kya hoga. Deepak.
Pankaj bhai, before Deepak saying.
Yeah, sorry, Dev bhai, आप आ गए. Yeah.
नहीं, मैं हूँ, यही हूँ, पूरा हूँ. आप जो इंस्टीट्यूट का एम्बलम देख रहे हैं उसके अंदर मैं ही बैठा हूँ पीछे से. So only because of the network being so bad, I'm in a car and using mobile net data. So I'll only just thank Ashwini ji for joining us today, and also Ashish ji for making it a double powered engine. So thank you very much, Ashwini ji, from my side. And tomorrow I'll ensure that I sit in my office only continuously. In my office also current has gone, so I thought I'll use my mobile phone, but again there is a problem with regards to that also. But look forward for meeting tomorrow again. Pankaj bhai, otherwise I am there with you always. But today, because of this all power cutting is becoming a little issue.
Yeah. I understand it was an exceptional day, but still many people are there. By 2 minutes hai, to Deepak, if you can just close it. Yes, Deepak.
Ashwini sir, thank you. You are awesome as always. Hello.
Yes.
सुने आ रहा है दीपक? दीपक, go ahead.
आज सरप्राइजिंगली नेट बहुत बुरा है
हाँ,
पंकज भाई।
दीपक आप अनम्यूट करके बात करो। आज बहुत बुरा है। हाँ, मैं भी 3 रख लेके बैठा हूँ। मेरे पास ये है, इसको लगा के रखा हूँ, फोन का कनेक्टिविटी लेके रखा हूँ एंड जियो का नेट है मेरे पास। यस दीपक, सॉरी दीपक, आर यू देयर? दीपक छोड़ दो, नेट खराब है। I will just become a secretary for some time. Sorry to barge in you. On behalf of Hyderabad branch of SRC of ICAI, I profusely thank Ashwini sir for this extraordinary presentation. I also thank Ashish Tandon for chipping in. I thank all the members who, in spite of the great difficulties, were part of the session, raised the question, and it was one of the best sessions we had. And again, whenever we have a best session, I give credit to Dhanivas Sharmaji because he is the one who proposes and brings such sessions, such excellent speakers. So I thank each one of you and I request all of you to join tomorrow earlier and have a memorable session. Look, today we had some rains and disturbed weather. Be prepared for it tomorrow because such sessions we are not going to have again and again. And it's an excellent learning for all of us. So thank you very much, all of you. Thank you.